Hey, hey, hey! We are live right now with Mary Naimish and her team. And Tursts and Estates, it's the name of the game. And I bet you there are a lot of you out there that don't have a will, don't have a trust, and don't have all your affairs in order. And Mary's going to make it really awesome and easy to talk about.
Well, welcome to everyone who is here in person. And thanks for joining us live, everybody. I am here to talk about estate planning because you have awesome real estate agents in MaryBeth Kellee and Philip Frederickson, and I want to thank them for recognizing how important estate planning is for everybody. They are your real estate agents, full service, and they're doing you a favor by educating you on estate planning. I have two of my associates here who will make some comments after I talk. Robert Allison helps in our family law department at Naimish Lewis, and Sam Tari helps in the Trusts and Estates and estate planning arena. So you'll see and hear from them. I am going to give a broad overview of estate planning and why everybody over the age of 18 needs an estate plan. And really, MaryBeth and Philip focus on people who own real property because they're real estate agents, but for everybody, we all need estate plans. Once you turn 18, you need someone who can step in and make decisions for you if you can't, with regard to both health care and financial management. And then you've worked hard for what you've built, whether it is a house that you have purchased, whether it is investments. You need to be able to pass those on to the people who you choose, not necessarily who's listed in our California Probate Code. You've worked hard, so plan your estate. That's the big message for today. And our firm, Naimish Lewis, is here to help you. We want to be a part of your trusted advisors. And for people who are here in person, my office and I prepared a little outline to kind of give you and not overwhelm you with some information on what happens if you don't have an estate plan and why you do want an estate plan. If you don't have an estate plan and you become incapacitated, someone probably has to go into court and get a conservatorship so that they can make decisions on your behalf. You can plan that in an estate. You can name a conservator. We see a lot of feuds, kids fighting over who's going to take care of mom or dad. But you know, if you have it in an estate plan, that's helpful. Estate management, that would be the purchase of a house, owning a home, rental property, and all of your investments, stock brokerage accounts, mutual funds, that sort of thing. If you don't set up a trust, you are facing a probate proceeding, which is a court-supervised proceeding, and your estate is going to flow by way of the California Probate Code. And I don't know about you, but I want to rule my destiny. I want to make sure that I have provided for my two boys who are young adults, who are now 21 and 23, and they may or may not be ready yet to manage my estate, but at least I can make sure that they're taken care of upon my death. So an estate plan, what is that? An estate plan can be one document, a will, for example, powers of attorney for financial management and health care management, and then a trust. And really, in the state of California, if you own real property, you want a trust. And you know, you don't have to have a large estate to have a trust. Really, everybody who owns real property in the state of California should have a trust. And MaryBeth and Philip make sure their clients are taken care of and follow up with them and make sure that they have trust and their property is in the trust. And because they've seen horror stories like we see in our practice. A will is appropriate for some people. If you don't own real property, a will may be appropriate for you. And it becomes effective upon death. You name an executor of your estate, and they marshal all of the assets in the estate. They pay the debts, and then the rest of the assets are distributed pursuant to the terms of the will. That's in a simple type of estate. With that, I would also, as my team would help with, we would also recommend powers of attorney for estate management and then an advanced health care directive. With a trust, that is a contract you're setting up during your lifetime. You're the person who has all of the assets. You're the person who manages those assets during your lifetime. But what's great is if you become incapacitated, someone's hit by a car, if you're a husband and wife, the other person can step in and manage the estate. Or if both husband and wife are hit by a car, you name your adult child who can manage your affairs. They can pay your bills while you're recuperating, and you don't have to go into court and ask for that trustee to be appointed. They're already there. Also, upon your death, again, the trustee would marshal all the assets into the estate, pay all the debt, and distribute your trust estate pursuant to the terms of your trust. Again, not by what it says in the California Probate Code, which is huge. You want your kids or your beneficiaries, whether it be relatives, friends, you can make gifts to. It could be a charity. And again, I don't know about you, but I want to say what my intent is, and I want it to be clear to everybody, and I want everyone to follow my wishes. And you worked hard during your lifetime, and I say as we get older, we're allowed to sort of dictate what goes on, wouldn't you say? So that's sort of a really broad brush overview, but the takeaways are, if you're over the age of 18, make sure you talk to a lawyer, hopefully Naimish Lewis, and if you own real property or you're looking for real property, you need to talk to MaryBeth Kellee and Philip Fredrickson, and then you need to come see Naimish Lewis for an estate plan, and we will help get you set up in what the best plan for you is. I also want to mention that these documents change over your lifetime. The birth of a grandchild, that's a life event that you want to say, oh, I gotta, think about what I need to do in that regard. If there's a death, we want to take a look at your estate plan and make sure things are updated. So as there are life changes, you'll want to change your documents. I'm going to have Sam Tari now come up and make a few comments on the trust and estate side of things, and then Robert Allison, who is an associate in the family law area in our office, will come up and make a few comments about some crossover issues if people are going through divorce, and we've got estate planning issues. Hi, Sam.
Hi, everyone. My name's Sam Tari. I'm an associate attorney at the Trust and Estate Department over at Naimish Lewis. And sorry, live stream. I just wrote up 10 key points or takeaways, I'd say. Just things to take into consideration when you're thinking about making an estate plan. Number one, be transparent. So if you do put that estate plan in place, make sure you let your family, your children, anyone who could be affected by the estate plan, let them know what you're doing. Because a lot of the time, issues arise when there's surprises. And you don't want surprises when you ultimately pass. You want everyone to know what's going on. Two is, I just want to reiterate, probate is long and probate is expensive. An investment in a trust now is really an investment in the future. It's making sure that your beneficiaries, your children, whoever's inheriting, things go a lot smoother and they're a lot cheaper for them. Number three, like Mary said, make sure your estate plan is updated. Things change, family dynamics, maybe you win the lottery, a lot of things can change. So you want to make sure that your estate plan documents are up to date. Number 4, plan for everything. So, a lot of times people are thinking about their will, they're thinking about their trust, how are my things going to be transferred? But they don't think, what happens if I am no longer capable of making decisions for myself? What if my health fails? A full estate plan will take those things into account. So they make sure that not only will your things pass when you die, but that you're taken care of in the event that something were to happen. Number 5, this one's a little specific, but just be wary. A lot of people say, oh, I put my assets in a pay on death account in my bank, or transfer on death. These things can avoid probate, but a lot of the time you're at the sort of will at the bank, and the banks are not knowledgeable or not helpful. So that's just a little specific, but just be wary about that. Trusts are a lot more flexible, a lot better. Number 6, keep records. A lot of the times, issues arise because people just don't keep track of things. And this, number 6, this really applies to all areas of life. Keep records, be organized. Goes without saying. Number 7, make sure your home is titled properly. So this one is an issue we run into sometimes. You make that trust, it's great, it's everything you want it to do, but the house never gets titled in the trust, or the bank account never gets titled in the trust. You want to make sure that your trust is actually working. So that means titling those assets in trust, especially the home.
And we help with that.
And we can help with that. And also there's joint tenancy. There's a lot of ways you can title your home. So just make sure it's titled properly. Number 8, plan ahead. A lot of times people come into our office, they say, I want to do an estate plan, they're ready. We send them the questionnaires, and then when it comes down to actually deciding how they want things to go, they kind of back off and they get scared. Maybe, I don't know what it is, they don't want to think about it. It's far away, but you want to just plan ahead. You want to make sure you have that assurance that things are going to go the way you want them to go. Number 9, be honest with yourself. If your family's fighting, if there are people who don't get along, that's not going to get any better. So make sure you can plan for that in your estate plan so things go smooth.
Tell us
Yeah.
Tell us their
Be
family
honest.
issues so we can help you plan.
And number 10 is charity is always an option. So, let's say everything to my kids. What about after that? I don't really care. There's always charity. They can be a contingent beneficiary. Maybe the chance that they actually get something is remote, but they're always there. You can always give to charity, and it is a great option sometimes. That concludes my 10 takeaways and points. So
Thank
And
you.
now,
thank you.
That was good.
and now Robert Allison is going to talk about a couple of family law crossover issues.
Which
with us.
no one in this room needs
Correct.
at all.
And I'm sure nobody who's
No one
watching.
needs
And I'll
like
be
this.
sure to keep it as short as possible so it doesn't even cross your mind.
Thank
No.
you.
This is for everybody's friends and family
That we
who's
know,
going through the
that we
issues,
can-
not all of you.
Exactly, and I'm actually going to start with not even a divorce or a legal separation topic. We're talking estate planning, and one vital document that I consider as estate planning is the premarital agreement. Especially for real estate agents, if you have a clientele and they're building their financial future, they're purchasing real estate and they're trying to build maybe their real estate empire, maybe not. When they are making their decision on whether they're going to live their life with their partner and become married, the premarital agreement is a vital estate planning document for them so they can protect their financial future. Another crossover area that I see when it comes to real estate is either on purchase or maybe during refinancing because of credit. Spouses will transfer the title of the property to one spouse or the other. And that does have very specific ramifications on the words community property and separate property. Now this isn't, this is a quick little primer and a bullet point to be sure to contact the professionals to ask about it. But one of the situations we see often, because individuals aren't aware, is they're essentially, it is called transmuting in our legalese, but they're giving their community property interest to their spouse, and it becomes their spouse's separate property interest.
Without knowing it.
Whoa.
Now they're without knowing it, and when it comes to saying hi to the judge in a divorce situation, it's often very shocking to hear that this is not your property. Now there's technicalities, it's really going to depend on what those documents say, so I definitely advise communicating with your attorney and those professionals. And lastly, my third point I really wanted to make is when, I guess you would say, contemplating a legal separation or divorce, once a divorce is filed, once the filing party files a petition, and then they have that petition and the summons served on their spouse, that summons contains what we call in the family law community automatic temporary restraining orders. In those restraining orders, 3 of them at least, restrain what each individual can do with their assets and debts, or not debts, but their assets, including their real estate. And when it comes to estate planning, it provides some restrictions. So a lot of what Mary and Sam were talking about are what we call non-probate instruments, documents you're preparing so that you can avoid the terrible probate court that everyone's telling you not get involved with. So what these restraining orders do, they prevent you from creating things such as a trust or revocable, irrevocable, and funding it. You can create it, but you can't fund it because you're not allowed to impact property that this other spouse has rights in. So you're allowed to revoke wills, you're allowed to create wills, you're allowed to revoke these non-probate instruments. There's some notice requirements, but you're not allowed to fund the trusts. So you might make a trust, revocable or irrevocable, that's not yet funded, so that you can shift your assets as they're divided by the court. Or you even would create a pour-over will to send any assets not covered by your other estate planning documents into that trust in time. So essentially, those are my 3 topics that I see often in these real estate planning crossovers with family law. Each one is entirely more complex than I've kind of just delineated. I always give those caveats. I don't want to give any information that people run somewhere, but talk to your professional, talk to your attorneys, talk to your real estate agents, talk to your CPAs, talk to everybody, and make sure you're well informed. So thank you.
Awesome. Thank you.
Thanks, everybody. Again, use MaryBeth and Philip because they are taking care of your real estate needs, and use a trusted legal advisor. Good to have a team of advisors. Thanks for joining.
Oh wait, I was going to ask a question before it all shut down.
Oh. Facebook's still on.
So, question that wasn't actually addressed technically. If you die intestate, you don't have a will, you don't have trust or anything like that, and there's intestate succession, which under the probate code says these people get these assets in this proportion. But what if there isn't any of those people? What if you have no family living and you haven't left a will or any of that? Where's that money go?
Oh, it's going to SG to the state.
Yes.
Oh, just what they need is more.
Give the state all your money.
Fix those
That's
potholes.
the last thing you would ever want to have happen, but that's exactly what happens if you die without heirs.
Right.
And you don't have a trust or a will.
And
And
that's
so-
why it's so good to do charities, universities,
Exactly.
right?
But you have to have a will for it.
Something, a will or a
Yeah.
trust, and something that's near and dear to your heart, like your children, your grandchildren, your family, your friends, and universities and charities.
Yeah, I mean, if you're an animal lover, donate to the Humane Society. Like, don't let the state have your cash.
Right.
You took enough of it during your life. They don't need more.
Exactly.
Right.
Exactly.
So I'll finish this and then we can ask questions. Thank you, thank you, thank you.